Welcome to Law Vidyapeeth. I am Dr. Nilesh R. Mate, a lifelong learner, a legal scholar, and many of you, someone who wants to understand how the law actually works in real life. Today, we are diving into one of the most debated topics in the modern world, the intersection of artificial intelligence, creativity, and the legal framework in India. AI is no longer a science fiction. It writes poems, paints portraits, composes music, and even drafts legal documents. But here's the big question. Our copyright law was written for humans, so where does AI fit in? AI is moving fast, but is the law keeping up? Let's find out. What is copyright? Before we talk about robots, let's first understand human creativity because copyright law begins here. Copyright is a bundle of exclusive rights granted to creators of original works, literacy, artistics, musical, cinematographic, and more. In India, this protection comes from the Copyright Act 1957. A key features of Indian copyright law is that the registration is not mandatory. Protection arises the moment an original work is created and fixed in a tangible form. Creators enjoy economic rights such as reproduction and distribution and moral rights including the right to attribution and protection against distortion. These human-centric rights form the foundation of today's AI debate. Defining the giant, what is AI? Now, let's turn into the other side of the equation. Artificial intelligence, AI, is not a thinking being or a legal person. It is a data-driven system trained on a massive data sets to identify patterns and generate outputs that appear creative. Whether it's ChatGPT writing text or an image generator producing artwork, AI does not create from imagination. Instead, it statistically recombines patterns learned from existing human created works. And that's exactly where the legal fiction being into consideration. Because if AI learns from the copyrighted material, can the learning itself be lawful? The big legal questions. This technology arises from four critical legal questions, questions that courts and the policymakers are actively grappling with. One, that is training data. Is scrapping copyrighted books, music, and images to train AI models a form of fair dealing, or does it amount to large scale infringement? Second, ownership. When an AI generates content, who owns it? The user who gave the prompt, the developer who built the model, or no one at all? Third, infringement. If an AI produces work that closely resembles an artist's unique style, does it violate copyright even if no exact copy exists? Fourth, privacy and personality. How do we regulate defects and unauthorized use of the voices, faces, and likeliness? These questions sit at the crossroads of copyright, privacy, and technology laws. The Indian context legal pillars. India's legal framework adds unique complexity to this. Under Section 2D of the Copyright Act for computer generated works, the author is the person who causes the work to be created. This provision becomes extremely relevant for AI generated outputs. However, unlike the US fair use doctrine, which is flexible and open ended, India follows fair dealing, which is purpose specific, such as private research, criticism, review, or reporting. This narrower approach makes it difficult to automatically justify AI training under existing exceptions, raising serious compliance questions for AI developers operating in India. Why this matters today? Policy landscape. These are not theoretical debates. They are happening right now in New Delhi. India is witnessing a collision between rapid AI adoption and the need to protect creators, users, and citizens. Policies like the IT rules, the Digital Personal Data Protection Act, and recent government advisors on AI misuse indicates a shift towards accountability. The government's stated objective is clear: promote innovation but ensure safe, trusted, and responsible AI, especially where IP and personal data are involved. A global perspective, international disputes, India is not navigating this terrain alone. Globally, we are seeing landmark lawsuits where authors, musicians, and media houses are suing AI companies for training on copyrighted material without consent. The European Union has responded with the EU AI Act, mandating transparency in training data. Meanwhile, courts in the US and UK are interpreting whether AI training qualifies as fair use. These global outcomes will inevitably influence Indian jurisprudence and policy making. Real life impact, celebrities and deepfakes. One of the most visible harms of AI misuse is the rise of deepfakes. Indian courts have acted swiftly to protect personality rights, recognizing that an individual's voice, face, and likeness are valuable legal interests. Injunctions against unauthorized AI generated content signal a strong judicial stance. The key takeaways: consent, disclosure, and labeling are no longer optional, they are legal necessities. The clash: fair dealing versus AI training. This slide captures the core conflict. India currently lacks a specific statutory exceptions for the text and data mining. Unlike jurisdictions such as the EU, AI training involves large-scale automated copying, which does not neatly fit within private research. This legal gap suggests that AI companies may soon require licenses, opt-out mechanisms, or legislative clarity to avoid infringement risks. The ownership puzzle. If you prompt an AI to create a painting or a legal article, do you own it? Indian copyright law emphasizes human creativity, skill, and judgment, while the law recognizes the person causing creation. Most AI platforms regulate ownership through end user license agreement. This means ownership often depends not on law but on contract. The result is a layered puzzle involving training data, algorithms, prompts, and platform terms. The roadmap: what's next for India? So, what lies ahead for India? Near term, government advisors on defects, watermarking, and AI transparency. In medium term, legislative or judicial clarity on AI training and data uses. In long term, harmonized intellectual property guidelines and national AI safety standards. India is clearly moving from reaction to regulation. And finally, why it matters to you. Whether you are a content creator using AI tools, a student researching emerging laws, or a lawyer drafting future proof contracts, this issue affects you directly. Documents your creative process, respective data sources, read platform terms carefully, and stay legally informed. If you found this analysis helpful, subscribe to Law Vidyapeeth and join us as we navigate the evolving world of law and technology. Until next time, stay curious, stay informed. Thank you.